I'm going to be very brief in introducing the speakers, and I'll just direct you to their biographies, all very impressive, which are listed in the conference program. There is one unfortunate change this morning, fortunate and unfortunate. Why don't I say that? The unfortunate part is that Professor Philip Girard is unable to be here, and I spoke with him a few days ago, and he was deeply upset about not being able to join us this morning. Fortunately, Professor Peter Carver, chair of the board of directors of the center, has happily agreed to step in, and he'll be delivering Philip's paper, which Philip was able to provide. So we have a stand-in for Philip, but we'll miss his presence. To begin, though, this morning, to lead us off, Ms. Louise Mandell. She comes to us from the West Coast and lengthy litigation experience working with First Nations people, and the topic of her title is First Nations Fight Patriation. Ms. Mandell.
Thank you very much. I'd like to begin by, Thank you. I'd like to begin by acknowledging the Cree Nation on whose ancestral lands we're having this important conversation. Thank the organizers for the privilege of being able to speak to you today, and to let you know that I've had the honor and privilege of being legal counsel to the Union of British Columbia Indian Chiefs and its member bands since 1977 through the Patriation debate and then into the litigation on Section 35. So to talk to you today, I have to return 30 years ago to myself as a young woman, a young mother. I was sitting in the office of the late Grand Chief George Manuel, who was the president of the Union of British Columbia Indian Chiefs, and we were together reading a confidential document which was prepared in October 1980 entitled Briefing Material on Canada Native Peoples and the Constitution. And this was the federal government's position, which had been slipped to George in a brown envelope. And the document said there is likely to be a major effort by Canada's Native peoples to win national and international support, especially at Westminster, for their stand against patriation. If the Native peoples press forward with their plans, and if they succeed in gaining support and sympathy abroad, Canada's image will suffer considerably. And then they go into the deplorable social statistics of Native people in Canada, and the report goes on to say that serious questions would be asked about whether Native people enjoy basic rights. Then the paper moves into what the Native position is. The Native leaders realize that entrenching their rights will be enormously difficult after patriation, especially since the majority of the provinces would have to agree to changes which might benefit Native peoples at the expense of provincial power. They therefore demand an entrenchment of Native rights before patriation. But the position of the paper was the strategy of the federal government was to promote formal discussions with Indian nations after patriation. The offer of post-patriation discussion would be used as the reason why constitutional participation was unnecessary. Well, George Manuel declared this to be a state of emergency and a threat to the survival of the indigenous nations. He argued that the issue was beyond consultation, beyond administrative battles with government, beyond petty politics, and was hitting to the very root of the existence of the indigenous nations. And a conference was called. Over 100 British Columbia Indian chiefs in assembly in November of 1980 stated their position, and I'll read you from a piece of it. Indian nations in Canada were never conquered. European traders and in later years settlers were made welcome in the land and environment which was alien to them. Throughout years of European settlement and expansion, Indian nations sought a mutual accommodation, one that would permit a bountiful land to be shared to the benefit of all. And then reciting their inherent rights, the statement goes on to say, Indian nations understood the Constitution to be a pact among founding peoples, among which we include ourselves. We understand our special constitutional relationship with the federal government to be in the nature of a partnership with the federal system, which was intended to permit us to survive and prosper as Indian nations while contributing to Canada's development. And so their position was that the Constitution was comprised of the peoples of Canada, represented by 3 sovereignties, the Indigenous Nations, Parliament, and the provincial legislatures, and that the root of the Constitution began with the Royal Proclamation, which was the document which enabled and entitled the British Crown to come to settle in Canada, where treaties would be concluded as the means of compacting. Treaties were concluded, and then when the B&A Act was established, there was a delicate division of powers where, under Section 9124, Parliament got power to safeguard Crown obligations and legislate in relation to Indians and lands reserved for Indians. Under Section 109, the provinces got their lands, mines, minerals, and resources subject to Aboriginal title being dealt with, and then Britain held the amending power. And the problem from the perspective of the chiefs was that they certainly didn't trust whether, if Parliament and the provinces retrieved the amending power, would they be able to amend the Constitution to the detriment of the Indian nations. And they had no reason to trust Canada. They saw that the whole constitutional debate, the whole living tree debate, was really Canada ignoring the roots and harvesting the fruit. And for those in British Columbia, unextinguished Aboriginal title, although the St. Catharines milling case said that the province's beneficial interest in the lands was available to the provinces as a source of revenue, and Aboriginal title was dealt with. In BC, they just stole it fair and square. And for the rest of the provinces where treaties were concluded, and in Edmonton, the promise at that place was that, said by the commissioners, the promises we have to make to you are not for today only, but for tomorrow, not only for you, but for your children born and unborn. And the provinces we make will be carried out as long as the sun shines and the river flows. But they were all subject to the doctrine of parliamentary supremacy. And so important treaty promises were overridden by laws of natural or general application. And it was important from the perspective of understanding what followed that when the white paper policy hit the decks in 1969, which was a Trudeau and Chrétien policy, one of the tenets of the policy was that the Constitution would need to be eliminated, eliminating all forms of references to Indians. And in the words of Mr. Trudeau, to end the legal distinction between Indians and Canadians. And so there was a lot of agitation about this constitutional debate, and it led to a lobby, both legal and political, which went first through Canada and also into Britain. And I'd like to spend a few minutes talking about what efforts were taken. In November of 1980, the Union of Chiefs presented a written argument and made representations to the Fourth Russell Tribunal on the rights of Indians of America and on the plight of the Canadian Indian in the Constitution debate. And the tribunal was comprised of international jurists who assembled in Rotterdam for the hearing. And the report, the tribunal condemned the domination of Indigenous people through constitutional reform. And it's kind of significant because George Manuel was both head of the World Council of Indigenous Peoples as well as the Union of Chiefs. And so you'll see in the events that unfolded that there was a lot of international play that we were directed to do as well as domestic. And he was above all a grassroots leader. And so the union was, myself as well, was sent into all the communities to talk about the Constitution. And I remember once landing in the middle of nowhere, at least it seemed that to me. It was way up in Owakino. They didn't have electricity there. And this rowboat comes zooming over to pick me up, and a young Indigenous man was in it, and he goes, "You a lawyer?" And I said, "Yes." He says, "Do you know anything about that so-called B&A Act?" And I said, "Yes." And he said, "Okay, get in." And so that was part of the organizing for the Constitutional Express, which eventually a trainload of people started in Vancouver. Hundreds of Indigenous men, women, and children, elders and leaders, left their home before Christmas, picked up people along the way, and headed into Ottawa. And if you ever want to think about an organizing event, this is it, because you have a cylinder of energy where people are talking and finding a way of meeting minds and taking on the Constitution. And when the train hit Ottawa, Trudeau Trudeau immediately announced that the Parliamentary Standing Committee would expand its timetable from December 1980 to February 1981 to hear representation from the Indigenous nations, among others. And previously, the Standing Committee had announced that it would not hear from the Indigenous people. Well, the Constitution Express was way over the Standing Committee, and they moved immediately. They were still like blurry-eyed off the train to the residence of Governor General Schreier and presented him with a petition and a bill of particulars to be delivered to the Queen, and then they journeyed to the United Nations to deliver the same petition. And I'm just going to read you the opening of the petition because it gives you a sense of where this was going. The petition reads, "An opportunity exists to elevate the constitutional amendment to an exercise in statesmanship and nation building. This is a course which we would welcome because it offers the possibility of creating a place for us in Canada's federal system consistent with our rights as Indian nations. We have given long and serious consideration in many assemblies of our people to the ways in which our special status can be integrated into Canada's federal system. We are convinced that this aim can be accomplished with the result of strengthening our Indian nations and of safeguarding the Government of Canada. This process, however, must take place before patriation." And what the petition asked for was internationally supervised negotiations between Great Britain, Canada, and the Indigenous nations. And when you actually look at the 12 points of the petition, what they're really laying out is a formula for recognizing coexisting titles, coexisting jurisdictions, and how to negotiate the jurisdictional interplay. And this was asked to be responded to by February of 1981, which of course it wasn't, and that led to the entire operation moving to London. And I just wanted to say here that one of the observations from the chiefs which came out of that period was the exclusion of the Indian argument from the forums where the issue was debated. And one elder put it this way. He said, "Canada is inside playing hockey with us, but they won't let us in the door. All we hear from the outside is the call of them scoring." And that was kind of an interesting observation because as soon as we went to London, the first obstacle that we faced was the Kershaw Committee. And this was a standing committee which was chaired by Sir Anthony Kershaw, which was there to investigate the role of Westminster with regard to the request to patriate. And the Indigenous people from BC had submitted a written submission and asked permission to make representation. But instead of allowing that, Mr. Freeland, who was the lawyer from the Foreign and Commonwealth Office, responded to an inquiry which appeared as a footnote to the report of the committee, asking whether, in his view, the Crown had any existing legal responsibilities under treaties made with the Indians, and he replied, "Not to my knowledge," and that was the entire Indian debate. And it was responded to in the press by a beautiful legal opinion, which was prepared by Rosalind Higgins, who is a professor of international law at London, and she asked such basic questions like, which obligations is he referring to? Have the Indigenous nations ever been told about it? Like, how did that all happen? And it stimulated a public debate, which we picked up in 1981 in the summer, where at All Souls College in Cambridge, the agenda opened up to talk about issues involving Indigenous nations and the Constitution. Well, at that time, this is another feature of the debate. We never had a forum, so we just kept making them up. And in this case, we made up and presented 2 memoranda of law to the United Kingdom Attorney General on the issue of Indian consent. And one memorandum of law cited all the provincial arguments and the other all of our arguments about why this bill should not go ahead. And we actually thought that as the Attorney General with the power to refrain from placing before Parliament Parliament a bill which is legally flawed, perhaps he just wouldn't do it. But obviously, it was more in the nature of the political lobby which took place based on the memoranda that we actually saw some results. The Union of Chiefs, the Federation of Saskatchewan Indians, and then the National Indian Brotherhood, we all were lobbying during that period in London. The task was immense. There was 635 MPs and over 1,000 members of the House of Lords. We lobbied them all. I don't have time, but I would like to say that one of the memorable lobbying experiences was with a member of the House of Lords, where we went in with some Saskatchewan chiefs, and he was sitting in a little room with his researcher, and he says, "Where are you from?" And one of the Saskatchewan chiefs stepped forward and he said, "Saskatoon, Saskatchewan." And the Lord looked to his researcher and says, "They don't speak English." Which was some of the problems we did face. Anyways, at the same time, back home, the women have occupied in BC the Black Tower, which is the Department of Indian Affairs office, and they were seeking an inquiry into the deplorable housing conditions, and this news reached London. The Saskatchewan chiefs were doing a cultural tour to Blackburn and Liverpool during the annual conventions of the Conservative and Liberal parties, and the Constitutional Express had moved from Ontario and had come across and had embarked on a tour of Hanover, Bonn, Paris, Landomark, Brussels, Amsterdam, and The Hague, and had landed in Westminster in London in November 1981 and held a potluck celebrating the ties with the Crown. And it was a very beautiful event. Some obviously strained questions came from the Friends of the Red Indian Society that actually existed in London, who asked if they could come to the potluck in full regalia. And we said we didn't think that was a good idea because most of the chiefs just looked normal, and here the only people that were in, full regalia were these British people. But anyways, nevertheless, with all of this intact, there was an amazing combination of press and politics and crazy and beautiful synchronicities unfolding. And in the end, there was 27 of the 30 hours used in the debate of the Canada Act dealing with the Indian question, thanks to those who were well versed and wanted to speak about it. And I'll just quote from David Annals, who was an MP, who summed up, I thought, what he understood the Indians were asking for in Westminster. He said, "The Indians are not asking for material assistance from us or for money. They're asking us to ensure, as we promised, that their constitutional status is protected in the renewed Canadian Federation. They have asked us for the constitutional tools to enable them to develop their own nationhood, their own forms of government, and to preserve their traditions." Now, at the same time that happened, there was 3 legal cases in London, and I'd like to just briefly make 2 points about them. The first was that these legal cases all proceeded after Section 35 was included in the Constitution. In other words, it didn't matter. Section 35 was not the First Nations' view of constitutional renewal. They did not see this as their effort to try to make a constitution happen for them. I think it's fair to say that because of the political efforts that they were taking on the international front, it made the negotiation, particularly the word existing and so forth, all possible. But they did not, they were there to deal with the constitutional principles. The Alberta case went first. It challenged the decision of the Foreign and Commonwealth Office that all obligations to the Indigenous nations had by 1931 become obligations exclusively of the Crown in right of Canada. That case proceeded on the basis basis of law alone, no evidence. And the argument was that as a matter of law, obligations had been undertaken by the British Crown, which had never devolved to Canada. And in every judge having a different view of what happened, they all said that obligations had devolved. Lord Denning, it was his last case. I had the privilege of being there. He said that the treaties, although made with the British Crown, the Crown was single and indivisible, but the law changed when Canada started to form, and by the Statute of Westminster, by constitutional usage and practice, he said, the treaties had devolved. Lord Justice Kerr had a totally different view. He said he didn't accept this transfer theory. He said treaties were made with the Crown and right of Canada because by 1867, Canada was big enough to make treaties. And Lord Justice May had a different theory. He said that independence was the key. When Canada became independent with the Statute of Westminster, so the treaties transferred. The Saskatchewan case was a different case. It was going in about evidence, with evidence, and the Saskatchewan chiefs, the crucial facts which they put in issue were that the treaties were concluded with the British Crown as a protection against Canada, that they would never have concluded a treaty with Canada, that their representations which were made to the Indians were that the treaty was with the Queen and the treaties were international treaties. This case was on April the 20th, 3 days after the Constitution was proclaimed, the British government successfully brought a motion to have these pleadings struck on the basis that the Alberta case had decided it. The third case was the Chiefs case. I'll call it the Manuel case. Over 100 chiefs from British Columbia on behalf of themselves and their nations. They had a different argument. Their argument was that they wanted a proper interpretation of Section 7 of the British North America Act, where everything moves, and there was certainly a lot moving during that period. I wanted to say that that movement helped create the inclusion of Section 35. I also want to say that that movement and the people that were on the train and went to London have been instrumental in the lobbying for the UN Declaration on the Rights of Indigenous Peoples and Canada's acceptance of them. And I agree so wholeheartedly with the beautiful comments made at the end of last night's speech that constitutional renewal has still yet to happen in Canada with the Indigenous nations. Thank you.
Well, from one set of synchronicities unfolding to another, the author of the paper, Professor Philip Girard, is a law professor at the Schulich School of Law. I still like to call it the Dalhousie Law School because that's where I graduated. The paper will be delivered, as I mentioned, by Professor Peter Carver of the University of Alberta.
Thank you. Thank you, Eric. It's an honor for me to be able to deliver the paper of Professor Girard, one of Canada's leading legal historians, and it's indeed unfortunate that he's not able to be here today. I've shortened the paper in certain areas in light of the time we have available, but if there is discontinuity at any point, you can safely assume that it's the editor's responsibility and not Professor Girard's. His paper is titled The Patriation Reference of 1981, Context, Impact, Legacy. He starts. In a recent article, constitutional law scholar Adam Dodek has called the Patriation Reference one of the most important and least read of all the constitutional law decisions of the Supreme Court of Canada. Pierre Trudeau called it the most important decision that the Supreme Court ever rendered or ever would render. And yet, like Trudeau himself, it haunts us still, although it perhaps haunts lawyers more than it does political scientists. Legal commentators were generally not positive about the decision when it came out, and most have remained skeptical and wary of it, though a new attitude of grudging respect may be emerging. Political scientists were not as negative as the lawyers about it at the time, but perhaps members of this audience can tell me if there has been any shifting of views over time within that community. I want to come at the patriation reference from two angles. First, I will ask whether law affected politics. That is, I will analyze the effect of the decision on the political actors. Then I will look at whether politics affected law. That is, whether the shape of the decision was affected by the hothouse political climate in which it was argued, considered, and rendered. Before I get to these questions, I will summarize briefly the way in which the matter came before the Supreme Court, and along the way, I want to flag the way the question of a referendum wove in and out of the patriation saga. As we know, it was the dissenting premiers who developed the court strategy in response to Trudeau's announcement on October 2nd, 1980, that he would proceed unilaterally with his People's Package of Patriation, a Charter of Rights, and an amending formula. The first two would become law immediately upon the passage of the implementing law by the UK Parliament, but the amending formula provisions contained the possibility that if agreement could not be reached between the premiers and Ottawa, a binding referendum would ultimately decide between a federal proposal and one put forward by a certain number of provinces. While the idea of giving the people of Canada the final say on a constitutional amending process was new, a process for consulting citizens on constitutional matters via non-binding referenda had been a priority of the Trudeau government in 1978-79. A Canada Referendum Bill, Bill C-9, was in fact extensively debated in the House of Commons in early 1979, but failed to become law before the election was called in March of that year. It would have allowed the Cabinet to initiate a consultative referendum on any topic relating to the Constitution of Canada, which was interestingly defined as including any, quote, custom, convention, or enactment, close quote, that comprised the Constitution of Canada, with safeguards on fundraising, access to broadcasting, equal time for provincial messaging, and the like. The significance of this failed bill will become apparent later. To return to the court strategy in formulating the questions to be referred to the provincial courts of appeal, the premiers made sure to raise questions of both law and convention, hoping that even if they lost on the law, they might secure a win in the court of public opinion on the convention issue. As this audience well knows, the court issued two majority decisions, the first deciding that Trudeau's plan to unilaterally request passage of his package from Westminster was legal, with 7 judges concurring and 2 dissenting, and the second deciding that with regard to the relevance of provincial consent, there was a convention, albeit unenforceable in the courts, requiring the consent of a substantial number of provinces, in which 6 judges concurred and 3 dissented. I will call the decision on the law Majority 1 and the decision on convention Majority 2. And then he has a title, Did Law Affect Politics? The Political Aftermath of the Patriation Reference. He continues, there is really no doubt about the ultimate answer to this question. As Peter Russell said recently in a review of Ron Graham's new book, The Last Act, the meeting of November 1981, quote, took place only because of a decision of the Supreme Court of Canada in September 1981, close quote. Nonetheless, the way in which that decision's impact manifested itself in politics and public opinion is of interest to anyone seeking to understand not just the patriation process, but Canadian legal and political culture more generally. In the immediate wake of the decision, both sides announced victory. Trudeau was informed of the Supreme Court's decision in Seoul, South Korea, on a stopover to a Commonwealth conference in Melbourne, where he would spend the next week. For a while, Chrétien and Trudeau played a good cop, bad cop routine, with Chrétien taking the hard line that Ottawa's win on the legal question was all that counted, while Trudeau dangled hints that he might be willing to consider more negotiations with the premiers. The extent to which the Supreme Court decision functioned as a game changer, as Carissima Mathen has called it in a recent paper, became quickly apparent. Within 2 days, the reaction seemed to throw the unilateral train right off the tracks, and indeed to threaten the future of the entire patriation enterprise. The NDP caucus met and announced that the party would withdraw its support of Trudeau's package unless the Prime Minister made one more attempt to negotiate with the premiers. This was highly significant as the Liberals held no seats west of Manitoba, so the NDP's backing of Trudeau's package had provided at least a fig leaf of Western support, which was now in jeopardy. René Lévesque wrapped himself in the mantle of Majority 2 and called the Assemblée Nationale into special session on September the 30th to debate a resolution condemning the federal government's unilateral plan as unconstitutional, a resolution supported by Claude Ryan and all but 9 of his Liberal MNAs. A referendum in Quebec and the possibility of provincial civil disobedience were also put on the table by Premier Lévesque. Behind the scenes, the federal Liberals in Quebec were terrified at Lévesque's response. The Quebec Federal Liberal Caucus was meeting in Orford, Quebec, during the week of September 28th. We know more about these events now thanks to the recent publication of the memoirs of André Burel, Trudeau's French-language speechwriter of the period. There was near panic, he reported, with many in the Quebec caucus so spooked by the prospect of a Quebec referendum on the package that they wanted to drop the Charter of Rights and just go for bare patriation. Marc Lalonde advised that Trudeau needed to reassure the troops personally by conference call because only his voice could possibly quell the panic. The Prime Minister did so by a satellite hookup on the 30th. Burel felt that a Canada-wide referendum was not possible because there was no general law in place authorizing one. Here is where the failure to pass the Canada Referendum Bill back in February-March 1979 perhaps played a crucial role. Had such a law been on the books and ready for action, Trudeau might well have decided to leap over the heads of both the dissenting premiers and the Supreme Court to see if he could get sufficient support from the Canadian people to proceed to London. Nevertheless, on Friday, October 2nd, the same day that the Assemblée Nationale passed its condemnatory resolution, the Liberal caucus voted with only one dissenting vote to urge Trudeau to proceed with unilateral patriation only if one more round of negotiations with the premiers failed. So, within a few days of the Supreme Court decision, Trudeau's unilateralist policy appeared to be in tatters, as the message of Majority 2 resonated with Canadians. He then moves ahead more to the week of negotiations in November 1981 and continues. While it is clear that the patriation reference had an enormous impact on the political outcome of the constitutional reform package, it is worth noting that it was not Majority 2 alone that got the ball rolling. Majority 1 confirmed that Trudeau possessed a powerful weapon, the legal right to proceed unilaterally to Westminster. The focus on Majority 2 in subsequent scholarship has obscured the fact that the patriation reference not only gave Trudeau an incentive to meet one more time with the premiers, it also provided the premiers with a strong incentive to come to a deal because of this legal ace in the hole on the federal side. Had the last round of negotiations in November 1981 failed, after good faith participation by the federal government, Trudeau recalled later that he would have relied on Majority 1 to take his chances with the British Parliament, which at that point might well have acquiesced. If it balked, he said in his memoirs, quote, "We would have had the option of a massive demonstration of national will leading to a unilateral declaration of constitutional independence from Britain," close quote. Had this route been taken, we would have had a truly autochthonous constitution. Judging from the opinion polls of the day, the package might well have won a majority in all provinces, including Quebec, and we might have been spared the subsequent years of wrangling leading to Meech Lake, Charlottetown, and the 1995 Quebec referendum. But of course, it is impossible to tell how much public opinion might have been swayed during any such campaign, especially in Quebec, where the federal initiative would have been fought tooth and nail by the PQ. In an interview with Ron Graham in 1992, Trudeau expressed regret about the path not taken. He said he felt he had, quote, "no choice but to accept the province's deal after Premier Davis's call on the evening of November 4th. But now I think it was a mistake. I should have gone for an election or a referendum. Quebec wouldn't have been able to say it was left out because everybody would have been left out. And Canada would have got a better amending formula and a better charter, close quote. That may well be, but Trudeau would have had an uphill battle convincing his own government and the people of Canada that a referendum was the best way out of such a political impasse. We move now to the second topic. Did politics affect law, the legal aftermath of the Patriation reference? Legal scholars have, by and large, not been kind to the Patriation reference. Many were and still are convinced that it was wrong for the court to pronounce on the Convention's issue. Professor Hogg said at the time that the only reason for the court to have done so was to influence the political outcome. Much less politely, Pierre Trudeau, a decade later, with one of the authors in attendance, said that the judges of Majority 2, quote, blatantly manipulated the evidence before them so as to arrive at the desired result. They then wrote a judgment which tried to lend a fig leaf of legality to their preconceived conclusion, close quote. Others have been critical from the opposite end of the legal spectrum, arguing that the court was wrong to draw such a bright line between convention and law, and should have recognized that conventions can become legally binding over time. My own view is between these two. As a legal pluralist, I do not see why constitutional conventions cannot be seen as a kind of law and the subject of court commentary in appropriate instances, even without benefit of the doctrine of crystallization. Such forms of law are arguably particularly suited to discussion in reference cases. My analysis stresses that the case's origins as a reference are crucial to understanding it. Carissima Mathen has recently drawn attention to the reference context of the Patriation reference. She notes that the reference power was included in the original Supreme Court Act of 1875, and that over time, the idea that such opinions were advisory only became replaced by the notion that they were binding. Only over time did that understanding come about. This is not surprising, given that the notion of binding precedent was itself largely a late 19th century invention that reached its heyday in the 1950s. By 1981, Mathen notes the reference jurisdiction was firmly entrenched in Canada, occupying a significant portion of the court's docket. Peter Hogg has stated that references are infrequent, but this is not true historically. About a quarter of all constitutional decisions rendered by the court between 1875 and 1986 were reference decisions. Barry Strayer, who did the empirical research supporting this figure, has said that both provincial and federal politicians came to view the reference procedure as an integral part of the functioning of the Constitution. The very ubiquity of the reference jurisdiction probably explains why none of the judges in the Patriation reference drew much attention to it as the means by which the matter had come before them. Not so the judges in the Quebec secession reference 17 years later. In that case, the court referred twice to the reference jurisdiction as advisory and situated it as an exception to the doctrine of separation of powers. It is, in other words, in the court's view, in the Quebec secession reference, an unusual jurisdiction, even if one that has been regularly invoked in the Canadian context. The tendency in the first half of the 20th century to assimilate advisory opinions to others rendered in traditional adversarial litigation obscured the extent to which the court was exercising a qualitatively different function in reference cases, one in which it might legitimately be more adventurous. I read the Supreme Court in the secession reference as returning to that initial idea of the reference jurisdiction as advisory and signaling that it might be willing to go out on a limb in a reference case in a way that it would not in ordinary litigation. Although the judges in Majority 2 did not say this expressly, I believe this is what they were doing. In the court of public opinion, the Supreme Court's decision was sometimes criticized for being unclear or confusing, but the judges were never reproached for answering the convention question. If anything, they were sometimes reproached for not providing enough guidance or more precise guidance. Their role in advising the political actors about both the positive law and the conventions of political behavior was not questioned, and the message of Majority 2 was immediately taken up by editorial writers across the country in both the English and French media. Clearly, the court enjoyed a high degree of legitimacy, even perhaps especially in the opinion of René Lévesque, who had previously castigated it for always leaning like the Tower of Pisa in one direction, close quote. And while some thought the court should have defined substantial provincial consent more precisely, most thought it was wise to hand this issue back to the politicians. In this, the court foreshadowed the clear majority on a clear question doctrine that it enunciated 17 years later in the Quebec secession reference. The Patriation reference and the reaction to it tell us something profound about Canadian identity, legal, political, and cultural. It tells us that we are a people for whom continuity is hugely important. I think this is the real reason that Majority 1 was framed in the way it was, in terms that some commentators found disappointingly static and almost colonialist in its recognition of the supposedly untrammeled powers of the Westminster Parliament to legislate for Canada. There is a phrase near the end of Majority 1 which seems almost a throwaway line, yet I think reveals something significant about the judges' underlying assumptions. They described the proposed joint address as, quote, an unprecedented situation in which the one constant since the enactment of the British North America Act in 1867 has been the legal authority of the United Kingdom Parliament to amend it, close quote. In the Quebec secession reference, after noting that our governing institutions have adapted and changed to reflect changing social and political values, the court went on to observe that this has generally been accomplished by methods that have ensured continuity, stability, and legal order. This focus on continuity within a stable legal order privileges the role of governmental institutions in effecting constitutional change, rather than the direct and unpredictable intervention of the people via referenda. In a political tradition where referenda are seen as divisive and exceptional, the role of the Supreme Court becomes that much more important as a guardian of the Constitution, and the reference mechanism that much more crucial as a way for it to play that role when there is confusion or discord among the primary political actors. The court somewhat hesitantly, and not without difficulty, embarked on that road in the Patriation reference 30 years ago. In retrospect, it was a turning point with regard to the role of the Supreme Court in Canadian constitutionalism, one that, as Edward McQuinney said at the time, was, quote, suited to the particular political temper of our times in Canada and transcended the more obvious imperfections of literary style and legal rationalization contained within it. Close quote. End of paper. Thank you.
Thanks. Thank you, Peter, for bringing us Philip's words. In the program, you might have noticed that Richard Simeon, a professor at the University of Toronto, was also to have joined us this morning, and unfortunately, in the last few weeks, he announced that he was unable to make it as well. So we regret Professor Simeon's absence. But I turn now to our next speaker. Marilou McPhedran comes to us from Winnipeg, Manitoba, where she is a professor at the University of Winnipeg and is principal of Global College and directs the Institute for International Women's Rights. She'll speak to us this morning on the women's rights lobby. So, Marilou.
Thank you very much. I think we could just start the video, please.
In response to overwhelming public interest, the Special House Senate Joint Committee on the Constitution received briefs from more than 1,000 groups from across the country. 300 organizations, from police chiefs to people with disabilities, made presentations on a wide range of issues. To make a presentation, you had to get yourself to room 200 of the Parliamentary West Block on less than 24 hours' notice, and your presentation could be rescheduled at the whim of the committee. On November 20th, 1980, the National Action Committee on the Status of Women had their say.
And I was just wondering why we don't have a section in here for babies and children. All you girls are going to be working, and we're not going to have anybody to look after them.
You were practically here the whole country ago. And I was in my living room alone saying, wait, what? Because I knew that once he said something so grossly ignorant and discriminatory, the public would understand what we were up against and would swing to our side.
About 3 weeks ago, a strange woman called my home. Her name was Linda Ryan Nye. And she said to me, are there women in Ottawa who would like to put together a conference? And I said, sure. She said, there are a few things to do. So she said, what about space? Oh, no problem. So we made some initial inquiries, and I contacted Flora MacDonald, who generated an enormous amount of interest and concern immediately in the conference and the idea, and was able to locate a room for us. As it happens, we began to grow in numbers, and the room wasn't quite large enough, and we needed a larger room, and that created a problem. But Flora MacDonald and Pauline Jewett, who are working together in this effort, were able to locate a larger room for us, the Railway Committee room. But we kept growing. This particular room, room 200, is the room that was being used by the Senate Committee on the Constitution. And we were told originally we could not have this room. But you see, we have this room. And it is with a great deal of appreciation that we thank and extend a great deal of gratitude to Flora MacDonald and Pauline Jewett and their staff. Welcome to Parliament Hill. This morning, as I was coming up to the hill, one of the people whom I meet regularly said to me,
"What are you doing going up there on a Saturday morning?" And I said, "Believe it or not, that's where the action is today." And that's not every day I can say such a thing about Parliament Hill. But we all know, we're all aware of the events that have precipitated this meeting here today. What I think is so marvelous about it, what I think is so extraordinary about it, is that it's spontaneous, that it's happened because women wanted it to happen, that there was no holding back, that there was no questioning or self-doubting. There was a group of women got together and said, "We will not be stopped."
My number 3, as a woman in favor of an entrenched Bill of Rights, I see it as really the only way to give a direction to the courts. The courts in this country have been interpreting our rights for years. They have been interpreting them in the common law tradition, or in the case of Quebec, in the civil law tradition. And they are not suddenly being given some power that they have not, in fact, already had. They have had it, and they have exercised it, I agree, prejudicially, often, to us. The courts already interpret our right to equality and have interpreted unfavorably. If we don't get a Charter of Human Rights which will explicitly state in so many words, very clear words, that what we want is not simply equality in the administration of the law, which is what they have been giving us in the common law tradition, or the civil law tradition, but that what we want is equality in the very substance of the law itself. We have to, it seems to me, give that clear signal, that clear direction, that clear message. But for the moment, we are asking ourselves whether or not we want to give this clear signal to the courts which have already addressed themselves to our issues. At the same time, we are also giving, by having a Charter of Human Rights and Fundamental Freedoms, and particularly with the affirmative action section, a clear message to the legislatures as well, all of the legislatures in Canada, and that's why I dearly hope this motion will be passed.
What you see here, a quote that on November the 6th, right after the announcement of the Accord, Pauline Jewett asked the Prime Minister, what about Section 28? Is the paramountcy retained? And as you can see, he says, the clause will continue, and points out that he was not involved in the drafting. I want to thank the conference co-chairs, Patricia Paradis and Lois Harder, and their hardworking team. And I wish to acknowledge that we are on the ancestral lands of Canada's First Nations. In keeping with the goal of this conference to enhance the historical record of the 27 days at the end of 1981 that gave us the Constitution Act 1982, the Honourable Judy Erola and I will share with you 2 perspectives on those 27 days. Mine as an advocate, largely excluded, and Judy's from inside the Trudeau cabinet. The slide that will come up shortly, this one here, you can see there's Judy in the front row beside Flora, Mary Eberts, Linda Ryan Nye, and as it stretches back, we had to turn away 300 people from this conference. This was the 25th anniversary of the Women's Constitutional Conference. Same day, back in room 200, 25 years later. Earlier this morning, I changed my speech due to a shock at last night's reception where two of the prominent men at this conference felt entitled to condescendingly joke about how they planned to chat during my speech because they already knew what I was going to say. Women's rights, ho-hum. Canadian constitutional accounts are steeped in history, his story of the executive federalism of closed doors and expense accounts. Different perspectives among them, certainly, but mostly from male insiders. And last night, I was reminded of their privilege, and it took me back. So let me quickly sketch the context for her story, women's constitutional activism, of which you saw just a little in the video. This changed the text of our charter, thereby affecting millions of women's lives. But it's still largely untold, and as I experienced last night, still comfortably devalued in the guise of a joke, not unlike Senator Hayes. So, 1967, our centennial year, Pearson names a royal commission on the status of women. 1969, reproductive rights, the criminal code is amended, but only if somebody else decides that a woman can have an abortion. 1970, Status of Women report is released. There are 60 recommendations. Most of those are still unrealized today. And in 1972, the National Action Committee on the Status of Women was established, and in 1974, the Native Women's Association of Canada was established. 1975 brought the UN Declaration of a Decade for Women and 4 World Conferences of Women that led to, among other things, the Beijing Platform for Action and the Convention on the Elimination of All Forms of Discrimination Against Women. 1978, Sandra Lovelace and other Quebec Reserve women lead a march of women and children from their reserve to meet Mary Tuak's early in Quebec and walk together, Aboriginal women and non-Aboriginal women, to Ottawa to protest Section 12(1)B of the Indian Act, Canada's first complaint to a UN human rights monitoring body. 5 Canadian women fought in the Persons case for 10 years, 1919 to 1929. But they could not afford to be in London, England, to hear Lord Sankey describe a constitution as a living tree, capable of growth and change, thus overruling the Supreme Court of Canada's denial of women as persons who could hold high public office, such as senator. Fast forward 45 years. The Canadian Bill of Rights mocked the Canadian women's equality before the law, resulting in such losses as in Laval and Bedard, because all Aboriginal women were discriminated against equally by Section 12(1)B of the Indian Act. And in Bliss, where the Federal Court of Appeal held that the prejudicial treatment of unemployment benefit applications based on pregnancy was not discrimination because of sex, but rather a distinction between pregnant women and all other unemployed persons. All pregnant women were treated equally. All Aboriginal women were treated equally, badly, so no problem. So by 1981, women knew how damaging bad human rights law can be for generations and for the country. 1981, the Canadian Charter of Rights and Freedoms is still being debated, and Canada ratifies the United Nations Convention on the Elimination of All Forms of Discrimination Against Women. In the brief video, you saw a fraction of the thousands of women in Canada bruised by the 100% failure rate using the Canadian Bill of Rights in the 70s, who mobilized the unprecedented grassroots campaign to amend the equality rights provisions in the proposed patriated Constitution, sending newly minted lawyers like me as unpaid women's rights lobbyists to Parliament Hill. First to the Joint Constitutional Committee, co-chaired by then Member of Parliament Serge Royal and Senator Harry Hayes, whom you just heard, from 31 years ago, and then for months of lobbying in 1981 to secure what our American sisters were failing to achieve in that same year, an equal rights amendment. By the time Doris Anderson protested the cancellation of the government-funded Women's Constitutional Conference by resigning as president of the Canadian Advisory Council on the Status of Women and igniting the ad hoc women's constitutional movement, Attorney General Chrétien had already agreed to some important rewording of Section 15, adding equality under the law and equal benefit of the law, with the title Equality Rights instead of the more minimalist non-discrimination rights, thus setting the stage for a constitutional doctrine of substantive equality, which you heard Pauline Jewett so eloquently describe as she influenced and indeed changed the vote at the ad hoc conference, of which I was a co-chair. I've been asked, how did the Equal Rights Amendment end up as Section 28, so far away from Section 15 and Section 1? I remember an intense debate in Mr. Chrétien's office when he declared that he would not make any more changes to Section 15 or Section 1, at which point we young women lawyers for ad hoc asked him to look closely at cultural practices such as genital cutting of girls, if Section 27 on multicultural rights stood alone. Not long after, I got a call to come to the Justice Building to negotiate what became the new Section 28 Sex Equality Guarantee. And the rest is her story. Between February 16th and April 23rd, 1981, with the advice of the renowned parliamentarians Reverend Stanley Knowles and Eugene Forsey, those of us virtually camping on the Hill devised a strategy that resulted in the drafting and highly unusual insertion of the Section 28 Sex Equality Guarantee into the Charter with unanimous all-party support on the floor of the House of Commons, accepted by the Senate on April 23rd, 1981. And then we tried to pick up our lives, deal with the damage to families, finances, and health that was the steep personal price for many of the ad hocers who held the campaign to strengthen women's rights in the Charter. No expense accounts, no pay. You won't find the largest mobilization of Canadian citizens on constitutional equality in the entire patriation process recorded in most curricula, journalism, or mainstream history as an important event. And for today's opportunity, I thank our hosts. Alberta's Penny Combe captured the drama in her book, The Taking of 28, recounting how this social movement had to be activated not once, but twice, in the same year. The second time following the summer 1981 reference to the Supreme Court of Canada and the November Kitchen Accord introduction of Section 33, often known, as we heard last night, as the notwithstanding clause, when in fact there are two notwithstanding clauses in the Charter, Section 33 and Section 28. As the summer of 1981 approached, none of us contemplated the possibility of crowds of angry women confronting premiers on the steps of their legislative buildings, or urgent private meetings with premiers and senior staffers to turn them from their determined course, or the telephone conversations arranged by Pauline Jewett with Alan Blakeney and his advisors to try and have a conversation about Aboriginal rights and women's rights not being traded off against each other. This was set by the November Kitchen Accord, and this created what was according to the Manitoba women who pressured newly elected NDP Premier Howard Pawley, a barter of rights. You saw my notes in green on the slide. That was November 10th, 1981 at 12:15 p.m. in a strategy meeting with the Honourable Judy Erola as Federal Minister for the Status of Women, when it was thought that if we could get just 3 premiers on side, we could undo the absurdity of the new Section 33 override spread over the existing Section 28 override. 28 says, notwithstanding anything in this charter, the rights and freedoms referred to in it are guaranteed equally to male and female persons. In 1981, Tarnopolsky and Baudouin said, Section 28 has also to be viewed in light of the limitations clause in Section 1 of the Charter and the non obstante clause in Section 33. Based upon past experience, there was fear either that the legislatures through Section 33 might, on the one hand, exempt a law discriminating against women from the ambit of the Charter, or, on the other hand, that the courts might, through the limitations clause in Section 1, so construe a law which discriminates against women as to consider it such a reasonable limit as can be demonstrably justified in a free and democratic society. Therefore, they said, the purpose of Section 28 is clear. Clear purpose, yes, but the impact of Section 28 is still an open question. Mary Dawson has written of the 2 versions of the resolution she hand-delivered to Prime Minister Trudeau. One where Section 33 trumped Section 28. The other, that Trudeau tabled and was passed with Section 35 on Aboriginal rights on that 27th day, December 2nd, 1981. But for what was in fact constitutional trialogue among governments, the court, and civil society, including Aboriginal leaders, thousands of women across Canada focused on protecting themselves and generations from the destruction wrought by the Bill of Rights. The Equality Platform for Transformative Cases and Laws, including 26 years of litigation by the Legal Education and Action Fund for Women, addressing disadvantage and discrimination, for example, First Nations, persons living with disabilities, gay, lesbian, transsexual, two-spirited persons, or Muslim women's claim to their religious and their equality rights. They could not have been secured. Thank you. Merci. Miigwech.
Thank you very much, Marilou. Our final speaker on this panel this morning is Ms. Judith Erola, a former Member of Parliament, as you've heard and seen, Minister of the Crown. And she'll also be speaking about the women's rights movement.
Good afternoon. I guess it is afternoon, yes. I'm not going to go over much of the material that Marilou has so eloquently expressed. I'll tell you about what happened as a result of the Kitchen Accord and what was inside the cabinet. And Mary Dawson, you're here. Now 30 years to the day has passed, and I can tell, can't I? Yeah. Okay. I feel very much liberated at this stage of the game. The role of women leading up to the final moments has been well documented, as Marilou has done, but I don't think that what happened within the cabinet and the difficulties we had getting the minds of people around the need to have Section 28 free and clear was that simple. Well, of course, there were a number of reasons for that. The issue of Quebec, we've gone through that, the disappearance of Aboriginal rights, but I suspect also it was because many of the male participants in this were oblivious largely to what had been going on in the area of Section 28. Most of the provincial ministers were not even aware of the intense negotiations that had been taking place prior to the Section 28 insertion. So my personal involvement began just a few months earlier when I was appointed the minister responsible for the status of women. The first woman to hold that post. Great consternation, imagine. At this point, the Constitution was in its final stages, and due to the brilliant efforts of women such as Marilou and her colleagues, it was now a fait accompli, and I felt very comfortable that we were moving in the right direction. Well, then came the final glitch, the fatal kitchen accord, the night of the long knives, and we were cut. Gone was Section 28, really written out by the override. I was unaware of this change until I was summoned to attend the official signing ceremony, which everybody observed was great pomp and circumstances. And I sat along with members of my fellow cabinet ministers behind the Prime Minister to indicate cabinet solidarity. In fact, I was seated next to Eddie Goldenberg. I think, yes, Eddie, you're here. I was seated next to Eddie, and he had, Mr. Kitchen's advisor, of course, and he had a copy of the text, and I asked for a copy. And I immediately recognized what had happened. Much to my horror, I discovered the override had taken place, and Section 28 was literally useless. Shaken and terribly angry, I rose to leave. I think you'll recall, Eddie, that you restrained me very quietly and said, "You can't leave," which was a good thing because it gave me a chance to think about what could happen, what should I do, and how could we turn this around. Of course, there's always that first impulse to fight or to flee. And I was reminded that Emily Murphy said the same thing, and she said when she had doubt, she fought. So I chose to fight, and in a cold, quiet rage, I attended the cabinet meeting that followed the ceremony in the railway center that afternoon. And of course, the full cabinet was in a celebratory mood, full of compliments to the Prime Minister and the Justice Minister, the Attorney General, on this really historic moment. So, turn by turn, there were great accolades being paid to the Prime Minister. Well, without any preamble, I expressed my shock and horror that 52% of the Canadian population had been left out of the Charter. The Prime Minister was taken aback, to say the least. And it was obvious that he had not had time to consider all the implications of the Charter, in fairness, but we were very clear, he and I, that what had happened was real by the end of that conversation. And then he, of course, went on the defensive, and we proceeded to have quite a heated argument. I should tell you now that when any cabinet minister dared to take on the Prime Minister, everybody stood aside to watch. This was going to be a good show. And they weren't entirely happy because this was supposed to be a happy celebration, and we were in the midst of another battle. Well, he went on and on about how we, Judy, did not take it out. It was the provinces. We had it in there, forgetting, of course, how hard it had been to get it in there in the first place. But the provinces took it out, so there's nothing to be done. The accord has been signed. Then we had a great discussion again how it simply was not going to be acceptable to the women of Canada, and that it had to be put in, and he went through the usual routines. Well, you know, of course, the rights of women are implicit. We went through the implicit, explicit arguments again ad nauseum, but I held firm. Sometimes cold rage is a great ally. And I said that we were going to change the Premier's minds. And the look on his face was really worth $1,000 because he looked at me and he said, "You, Judy, you're going to change the Premier's minds?" And I recall saying, "Not me, Prime Minister. The women of Canada are going to change the Premier's minds." He then said, "And how are you going to do that?" So I swallowed hard and outlined what I thought was the plan. I hadn't consulted anybody at this stage of the game, But I knew one thing. Throughout the course of events leading up to the Charter, the Women of Canada had been part of that discussion for a very long time. They had, of course, started with the hearings of the Royal Commission back in 1967. They had been consulted for years across the country and had spoken loudly and clearly. I also knew that through the results of the ad hoc committee, through the work of NAC, the National Action Committee, and the Canadian Advisory Council on the Status of Women, led by Lucy Pépin at that time, that we had an incredible data bank. But remember, in those days, we had no tweets, no email, no faxes. So when looking back on it, it was really quite amazing the way we were able to network across the country without that. We did have telephones, a woman's best friend. So I outlined to the Prime Minister the strength of the lobby that existed as a result of the work leading up to the Charter. We would work together on this huge task. To say that the Prime Minister was dubious is an understatement. He pointed out to me that it was unlikely that this would happen, that I, as a member of the federal cabinet, could not be seen actively opposing the Charter, therefore breaking cabinet solidarity. So I said, let's make a deal. I will utter no press statements. There will be no public statement. I would work underground completely with the women of the country. But it was understood that should this blow up and fail and result in a big discussion as to what my role really was in cabinet, I replied that I would resign. After all, there was no point in being the minister responsible for the status of women if women had no status. So the meeting finally came to an end, and I sensed that with the exception of my friend and colleague Monique Bégin, others did not hold much hope for me. And so we began the campaign. I called all the people I knew from the earlier fight, and every resource in my political office, the Status of Women, the Canadian Advisory Council on the Status of Women, and our provincial counterparts, everything was activated. The databases were mined and the lines began to ring, and the ad hocers and all of these people who'd been there came into the offices and never left the telephones night or day. In fact, many of us didn't sleep, I think, for much of that time. There was an effort to contact every women's organization in the country to lobby their provincial premiers. Many organized marches to the provincial legislators. But really, really important was the role of the women in the House of Commons. Flora MacDonald, Pauline Jewett, and Margaret Mitchell whipped, and I mean whipped, their respective caucuses into shape. And they also kept up the pressure in the House. This was truly nonpartisan cooperation at its finest. They crossed party lines and said, no, we have a more important job here, and we worked together. And it is interesting to note that no time in this debate did the Prime Minister nor any of the other ministers, with the exception of Monique Bégin, acknowledge the efforts of women across the country. We had powerful allies in Quebec, never truly acknowledged, the Yvettes, that incredible movement that saved us earlier. The Liberal Women's Commission, led by Loris Talmy, they integrated their networks with the lobby, so there was a great deal of work inside and outside. So what began as a movement by what I would consider elite feminists and who began the work became a mass movement of women from just about every socio-economic level. We had support from the IODE, the nurses' unions, the teachers, the Catholic Women's League, the Business and Professional Women's Club, the University Women's Club, the Women's Institute. Oh, I love them. As a rural child of a WI member, I knew what potent pests they could be. So I've named just a few. We were a disparate group, but with one objective. That equality clause had to go in free and clear. They marched on the provincial legislatures. They flooded the provincial MLA's offices and the Premier's offices with phone calls. It was quite magnificent. And yet, the press, with the exception of some notable women columnists such as Michelle Landsberg, paid scant attention. And there are a few cracks beginning. I began to worry when a group which calls itself the Real Women emerged and gained some momentum by introducing abortion into the debate. There was just no time to lose because it was beginning to crack. As the premiers began to crumble, with Alberta, Peter Lougheed leading the way, and Ontario, we were beginning to encounter some provincial resistance as well. I recall one funny story. Premier Buchanan was nowhere to be found of Nova Scotia at the time. You're here today, so you can verify this story. I called Flora and I said, Flora, we can't find Premier Buchanan. And she said, I'll find him. He used to take my sister out. True? So you see, I'm telling the truth. So she found him. You were in New York at the time, I think, weren't you? Yes. She said, I found him in New York and he's in. She delivered. I know. She said she harangued you for 2 hours, maybe a slight exaggeration. Day by day, we tracked our progress, and it became clear at one stage that we were almost there. However, at one point in the heat of battle, a senior bureaucrat at the Status of Women offices informed me that using the Status of Women resources for political purposes violated the rules. I said, who cares? I knew that at the end of the day, it was win or lose, and we'd had to use everything we could. It was never brought up in the House after that, ever again. So I'm confessing my sins here. But by November 16th, in response to a question from NDP leader Ed Broadbent, and I really have to admire Pauline Jewett because she was very circumspect in her questions, direct, but she was, of course, part of the background work going on. She kept up the pressure in the House, but she had her leader, Ed Broadbent, ask what was happening, and I was able to respond that honourable members, we are optimistic at this stage and hope that Clause 28 in the general section will remain intact. We may know by the end of the day. However, the end of the day was too soon. Mr. Trudeau was asked in the House if there was a holdout, and he acknowledged that, but refused to name Saskatchewan as the lone holdout at the time. Premier Blakeney was stubbornly holding the Equality Clause hostage to Aboriginal rights. So behind the scenes, Women New Democrats Pauline Jewett and Marion Dewar went to work, and it was quite a job. They were in Regina, and they were there to convince the Premier that the Equality Clause was as important to Aboriginal women as to other Canadian women, perhaps even more so. Outside the legislature in Regina, and that was a cold, cold night, there was a massive rally of women demanding that Premier Blakeney support Section 28. So finally, on the evening of November 23rd, Mr. Chrétien rose in the House to inform members that he had obtained from all provinces which are parties to the Accord their agreement that Section 28 on the equality of men and women should apply without the override clause. We won. The women of Canada won. So I'll end with a quote from Pauline Jewett, who said in the House of Commons in reference to the Kitchen Accord, if there ever was a time when a woman should have been in the kitchen.
Thank you so much. I didn't know that Section 28 turned on a kiss in North Sydney, but this conference has already been worth it. Thank you for those, all of the presenters on outstanding presentation.
Hi. Hi, Mark Crawford at the Basque University. I just wanted to ask the panelists if they could comment on the impact of Section 28 on jurisprudence since then. I mean, has it been mostly a kind of preventive measure that's kind of shaped legislation, or can you actually point to laws that were struck down or altered because of Section 28?
Well, as I said in my presentation, the purpose was clear, but the impact is not clear at all. Section 28 has not been widely used. It was argued quite strongly in the Native Women's Association of Canada challenge in the Charlottetown Accord process, and was largely dismissed in the decision of the Supreme Court in response to that. And for reasons that certainly I don't know, LEAF never even argued Section 28 in the sex equality case for Newfoundland and Labrador. So as Peter Hogg, among others, has observed, it could have turned the case. It wasn't argued. And as a result of that, it remains an open question that at what point will potentially 28 and 33 be pitted against each other? How will that evolve? It just hasn't happened in 26 years of litigation.
However, I would like to add that as a result of this, the entire climate for the role of women in society has changed dramatically. We can't help but look at how we now look at pension benefits, at maternity/paternity leave. All of those things are now a given. I think I sum it up best by a comment made to me by my son-in-law, who was looking at my text because he was fixing my computer for me, and he read the equality clause, and he read it over and he said, "Duh." It's a given now. It permeates society. However, I do feel that it is not well enough known, that it is not examined as it should be examined, as you have pointed out, Marilou, and that I think that you as academics in the field have a duty to examine this and bring it forward as the studies of the Constitution go on, because it really isn't studied. I've talked to a number of young people who are totally unaware of this part of the Constitution battle.
Thank you, Louise, for your speech and everyone else. I had a question. Do you think,
Could you identify yourself?
Shailene Jobin from the University of Alberta, do you think that Section 35 has had the impact that Indigenous peoples at the time thought it would, now reflecting 30 years later?
Okay, that's a beautiful question. Thank you. Section 35 has been subject to the court process of the court basically making up law. We had no idea that the justification analysis that came about in Sparrow would be the result of Section 35. The court just made it up. And similarly, the doctrine of reconciliation was also a doctrine that the courts have just made up. And so I think we would have to say that nobody, even those people who were advocating for the inclusion of Section 35, could have predicted all what the courts have done with it. But having said that, it's very hard to say whether or not some of the cases that we've won since Section 35, including the Sparrow case, Delgamuukw, where the courts have determined Aboriginal title hasn't been extinguished and it has a jurisdictional and an economic component, the Haida case that's put constitutional obligations on the Crown arising from the assertion of sovereignty to consult and accommodate. We don't know whether or not these decisions would have been possible had the court not also started to build justification and reconciliation into the picture, even though on some argument maybe they could all have been decided based on the B&A Act division. The fact is that reconciliation has given the court a way to balance the interests of third parties and encourage negotiation as part of fulfilling the constitutional rights embedded therein. So I think that we would have to say that no one could have guessed it. We didn't argue for it. This is what's come about. And in some cases, it's really the jury's out, whether or not this is going to achieve the recognition of the of title, of treaties, of self-government, of the sovereignty issues, which are part of finding a way for coexistence to take place on a jurisdictional and a title level. We haven't achieved that. On the ground, we're still facing the same deplorable social circumstances that were recorded in the briefing note.
We have time for one quick question and a quick answer.
Okay, I'm Yasmin Abu-Leban from the Department of Political Science at the University of Alberta, and I want to thank the panelists for reminding us all of the struggles of different collectivities to have their rights recognized within the Constitution. My question is directed at Marilou McPhedran. I was struck by your discussion of a kind of pitting of Section 28 against Section 27 and the argument around female genital mutilation and how that somehow moved Section 28. And I think what struck me is that it's very reminiscent of a lot of the debates we're having today, which kind of pit gender equality against particular collectivities, racialized collectivities. So I want to ask if you have any more elaboration on that point and how you view it now, thinking about the agenda of an anti-racist feminism.
Boy, I'm not sure that could be a short answer, but try.
Give the truth.
I think the understanding that has been built over the last 26 years of litigating on these matters and thinking and writing and an appreciation that simply wasn't operating in 1981 around intersectionality has been informed by the sections of the Charter that can be seen to be pitted against each other. I'm simply telling the truth about the meeting with Attorney General Chrétien and the fact that it resulted in a phone call. I don't know what process happened within him or within his department. Now, I served as strategic counsel for the Canadian Council of Muslim Women for the years in Ontario of the battle to have it clearly defined that Sharia law would not be allowed under the Arbitration Act of Ontario. And if ever there was a scenario that showed that it's very, very important to not push people, rights-seeking people, into a situation where they have to choose between one or the other. And much of that debate was framed as one of freedom of religious expression as defined by a certain leadership within the Muslim communities versus what the Canadian Council of Muslim Women was arguing was that they had their rights to equality and their rights to religious expression. They did not see a contradiction in that, and they did not feel that either their religious rights or their equality rights were furthered through the embedding of Sharia law into the Ontario legal system. And I think we take these cases case by case. The debate that has gone on for some time now around the wearing of the niqab in Quebec, the cases that also involve, for example, the Mennonite Brethren in saying that they won't have their pictures taken to go on driver's license, and that battle with the government of Alberta. We're going to see many different scenarios that will take these sections into account. I think, though, that what we're left with is that there's very little to be said, or that the courts have said in terms of 28, because it really hasn't been argued that much. Now, I'm happy to report that Carrie Frock, who's with us, is doing her PhD on this very topic. So I think it'll be very interesting as the scholarship grows in this area.
Thank you. I have